What you're going to see in front of you is a bunch of legalese. Okay, this is Section 32 of the Environmental Bill of Rights. There's some wording, and some of it's in white and some of it's in yellow. The way you read law is just read the yellow. That's an interpretation, and that'll be my point. Okay, ready? There it is. Section 22, which happens to be the posting on the environmental registry, the notification comment provisions. Section 22 does not apply where the issuance of an instrument, that means like a license permit, would be a step towards implementing an undertaking approved by a decision made under the Environmental Assessment Act. They put in this thing, and on the face of it, it's not bad. What this is, the legal stuff they put in there. And it basically was said, well, if we have something going through environmental assessment, then, there's no point in putting it through the Environmental Bill of Rights, too. That's like double jeopardy, right? They're going to get environmental assessment. Implied in environmental assessment is all sorts of meetings and discussion and consultation. So why would you have two consultation mechanisms on one decision, right? Reasonable. I don't have a problem with that. But then we have these people in the legal profession that take the words and give another interpretation to them. So their interpretation is, okay, anything that goes through environmental assessment process doesn't go through ABR. Okay. So if something is exempted from the environmental assessment, that's like going through the environmental assessment process because it got exempted. So it doesn't get considered on the ABR. Okay. So we have things like the best example, your first example, a big one, is the Darlington nuclear plant, which was exempted from the environmental assessment process. So on that day and forever forward, if the Darlington nuclear plant has an air emission, a water taking, or any kind of environmental thing like that, they are exempted from being posted on the EBR. You will never know they occur because they forever went through an environmental assessment process, which was to exempt. Now, it happened again recently. I mean, it happens all the time. Some things are left out of EBR by this thing. The one that was neat more recently is, you might have heard of this IPSP, the Integrated Power System Plan thing that they put out. It was the proposals. It's gone through some changes recently. But in the original, the first time they did, they said, okay, they announced they're going to have the Integrated Power Supply Plan, and part of it was going to be the new nuclear builds and things like that. And so what they did is they announced it and they designated it under the Environmental Assessment Act. And then by regulation on the Environmental Assessment Act, they exempted it from environmental assessment, which at the same time removed all of the power planning from review under the Environmental Bill of Rights. Now, but just for fun, they made a mistake because the regulation that is posted to exempt it has to be posted on the Environmental Bill of Rights. And they forgot. So I mean, it was a one-day wonder, but I got to just jab it in there a little bit to say, no, you broke the law. But anyway, the IPSP has been buried, so it's a moot point. But I want to make that point is there are these outs that the government uses from time to time, and I rail at the winds against them, but from time to time they win.